There we go. All right, Paul, do you want to give your usual disclaimer? Looks like we've leveled out with participants here. We're about 60.
Okay, sorry, still having technical difficulties, but I think I fixed it now. So yes, whatever information we give you for today is only good for today. Things, as you know, since last March have been changing rapidly. They change daily, hourly, what have you. The good news I can say for the first time is that things are finally changing for the better. So when you hear new changes, hopefully it's going to be things are just getting better all the time as opposed to worse. I'm hoping that the word moratorium can finally be eliminated from our vocabulary in the not too distant future. I think we're actually getting there. And certainly the word COVID-19 or the phrase or the term or whatever you want to call it, the virus, COVID-19, hopefully that'll be gone from our lexicon also. I can't wait till that day happens. But we are moving closer to it. I saw Philadelphia now has 70% of people have their first vaccination, which is incredible. So it's going to be really hard for the government to continue all these moratorium and other things that they're doing to inhibit our freedoms and what have you.
You know what's funny? The other day, Paul, I went a whole
What?
day without talking about COVID-19, I realized. And I just laughed. I think that's the first time that happened in a year and a half. I mean, it was a weekend, so I didn't have to, talk about it in the context of work, but it was pretty funny.
Yeah, it's incredible.
Okay, so we just wanted to give everybody an update on a few things that are happening in Philly, a couple of which have nothing to do with COVID. Paul is going to give you a few updates on some laws that have been introduced that we passed or were passed. Did they get passed last Thursday, Paul?
They're going to get most likely going to get past this Thursday.
This
with the
Thursday.
final reading.
So Paul's going to give you an update on that. And then we want to talk to you about what's going on with phase 4 rental assistance, the rumors we're hearing about the moratorium, and when we're going to be able to start getting closer to back to normal, what we're hearing. Of course, nothing is set in stone and concrete, but it's sounding like, as Paul said, we're moving in that direction. So we'll kind of give you an update on all of that. Where do you want to start, Paul?
Yeah, what's crazy is that, Janelle and I and these Zoom talks, and we plan on sort of a general and what we're going to talk about. And by the time the week goes by, I think it's changed much that we're talking something completely different, or giving you new updates to it, or telling you what's coming down the pike.
You're doing next. That. You're echoing again really bad, Paul. I don't know why.
Hold on.
We're kind of hearing everything you say twice. It's kind of fun. Anyway, while he's doing that, we're going to talk. I'll start. We'll do the laws at the end, then, Paul. We'll start with phase 4. That way, I can start a little bit with some of the things that we just kind of wanted to explain on our end. So we have been doing these phase 4 rental applications now for a few months. Everything started in April. And everything keeps changing. The city keeps changing the rules on us. I don't want to say the laws because the laws haven't changed, but it's their interpretation of laws and how they're doing things. So it's kind of throwing a monkey wrench into things. We have had some applied. I mean, Lex can probably speak on that, but we've had some approved, not applied. We've had some approved. We've had some money distributed, which is awesome, that have gone out to our clients. We've had a couple that were denied, one of which was pretty funny. The tenant didn't even meet the income threshold. They were over the income threshold. So we've had some that were denied. So we are getting to some of the final stages of them, which is great. And we're starting to see some money in our clients' hands over the last few weeks, which is really awesome. One of the things that happened in the city is originally, and the law is written such that the city required us to have the tenant's permission in order to go forward with the phase 4 rental application. So originally we had submitted a bunch of these applications and we had tenants sign off on something saying we had their permission, and then all of them got rejected because in the meantime, the city developed a form that the tenants had to sign, that they had to certify, and that all the information was correct. So then, I mean, it wasn't a very big deal, but we had to go back and get these forms signed by the tenants and upload them to each one of these applications before they would get approved. And that's something that happened. What?
You got, you hear me now? Is it good?
Yeah.
Good? Did I fix it?
Talk again.
Is it good now?
Yes.
Good now?
Yep, better.
Okay.
Okay. So that's
Yeah,
something
sorry
that happened.
about that.
Yep, it's okay. That's something that happened. You know, the city made this form a month after everything had been going underway. So they kind of changed up the rules and we had to have that signed. Another thing that happened was the city.
Yeah,
had
real quick. I just wanted to interject. There is,
Nope.
it's amazing that
You're still really bad, Paul. I'm sorry. Is it because of your headphones?
no, I switched everything because I had to do it on a
That's
different
better.
system.
Keep it just like that.
Okay, good. Thanks. So I had to change all the settings because I was doing it on a what's that, Microsoft Teams.
Oh, Teams.
Yeah, so now I'm trying to switch it all back and remember what the original settings were, but we're good now.
Yep, that's perfect.
Okay, so just so you know, so we try and stay ahead of everything. So the laws get passed, we go ahead and figure out what the law says. We're ahead of everybody in figuring out what it says and doing it. We follow the law to the letter and do exactly what we're supposed to do. And then the government comes along and says, oh, you know, we're just kidding. That's not really what the law is. We made a mistake. Here's what we need you to do now. And then now we're switching everything and changing everything to now comply with what's not the law, but what the city's interpretation of the law is. So my new favorite expression is that it used to be the early bird gets the worm. I'm sure you all heard that expression. Now the new expression that I have is the second mouse gets the cheese. You got to think about that one. That's what happened to us. Like, we're the early bird, we're ahead of everything, we're on top of everything, we're getting the worm, but we're not getting the cheese. We're just
we're getting our head snapped now.
Yeah, exactly.
Done.
So it's crazy, but that's what's been going on for us for months and months and months now. But I think we're finally at a place now where we know what the laws are. They're pretty much ingrained. Things are, like I said in the beginning, are starting to get better now. So we're in a much better place, and we'll get through this all together.
One of the other things I wanted to mention in that vein, just so that you guys know, so they originally explained to us that we had to have the tenant's permission. So we reached out to the tenants for 3 times. One of the things they said is we had to, reach out to the tenant 3 times. So we had done that. And now they're telling us that that's not enough, that you have to fill out the first 2 pages of the rental application to get it in as a draft, in addition to the reaching out to the tenant those 3 times. So again, like Paul said, they just keep changing the rules on us and it kind of setting us back again. And the other problem is, as Paul was saying, not only are they changing the rules, but each department's changing the rules. So you have the courts, interpreting it one way. You have a completely different department running the phase 4 rental application, and their website constantly has glitches. It's slow. One time Marley was showing me, she took a video of it, of how long it was taking the process. It took almost 2 hours to process one application because of how slow the website was working. And then you have a completely different department that's administering and helping to go through these rental applications. So, and dealing with, the mediation with, with regard to that. And none of them talk and none of them know what the other one's doing. So it's very, it's interesting how it keeps changing because of the various different departments that are involved with this part of the process.
And they're calling us and asking us questions.
Yeah. The one lady at the one department.
They're calling us. We're like, okay.
Yeah, Amanda Lux here. You can see her on the screen. Wave, Amanda. She has been dealing with the city daily. They're best buds now, her and a couple of people in the departments. And it's getting to the point, but because, like Paul said, we're interpreting these laws, that they're coming to us for the questions, which, that's not bass backwards. I don't know what is. But okay. So like Paul said, I think we're kind of getting to the end of the rope. I think we started to hear, Paul, what did we hear about with the funding? We had originally thought, and the city thought, that the funding for this was going to go through, the end of the year. It doesn't sound like that's going to be the case anymore. And when the funding runs out, we should be back to normal.
So what happened was there was $46 million that was appropriated to the city under the Budget Reconciliation Act back in December. And when money is appropriated to the city can make rules and regulations for how that money is going to be distributed. So for those of you that were involved in phase one, phase two, and phase three, it was a disaster in the rules and regulations that the city came up with. They were very hard to comply with. There was a lot of documentation that they were looking for. They only allowed you to get a certain amount of money. You had to waive the rest of the money. It was just a disaster. And what ended up happening is a lot of that money didn't get spent. And any money that doesn't get spent goes back to the federal government. So when phase four came out, the city said, you know what, we're not going to let that happen this time. We're going to make it a lot easier. We're going to make sure that we get that money out to everybody. That was the goal. Unfortunately, that's not what's happening yet. For those of you that have been applying for waiting for their assistance, you know what I'm talking about. It's been very difficult to get the money. There are just so many different roadblocks. For anyone that's written computer programs, you know what a nightmare it is to put a computer program together quickly. That's very complicated, that a lot of people are going to be using without testing it. Normally, when you put out a computer program of that magnitude, you test it for 3 months, 6 months, you have people work through it so you get all the kinks out. Instead, the kinks are being worked out live. So they go live with the program. There's all these kinks, there's all these problems. They try to fix it. In trying to fix it, they create another problem. There's things they didn't even realize needed to be into the computer program. So we're working with them, we're helping them, we're working through all these different issues. But as you can imagine, that's just one of the problems that we're experiencing with the phase four rental assistance. The state has realized that the money is probably not going to all be given out by the city. And any city or county that has 200,000 people within their jurisdiction can make their own rules for giving out the rental assistance. So the money is appropriated first from the federal government to the states, then any municipality or city within that state that has over 200,000 in population gets the money directly and can make their own rules and regulations. State realized Philadelphia, Pittsburgh, and other counties aren't going to be distributing all that money. There was an additional 41 million that's been appropriated under the American Families Plan. I think that's what it's called. I can't keep these acronyms and names together, but the money that was appropriated in March, the last appropriation. Okay. Now, that money was also supposed to go to the city. The state is now, and this is happening as we speak, the state realizes that since the city and the counties haven't been able to distribute the prior round of money, they don't want to just give that money to the cities and counties again. So the state is in the process of making their own rules and regulations for being able to distribute that additional money. So here we are now where the city has the initial funding and they're now getting all these applicants, and with all the applicants that are there, there's not enough money for all those applicants to get the money. The city was hoping for the additional funding. Now we're being told that possibly, we're not sure, that money may have to be distributed on a state level. So the question, there's a million questions, but one of them that I've been asking is, okay, so you now have applied for the money through the city. Now the money's not being distributed through the city, it's going to be distributed through the state. What happens to your application? Does that get transferred to the state? Do you have to have a new application with the state? Are you going to still be first in line when it gets transferred? Are you going to have to reapply over again? Now you're back in the queue. Like, there's so much that's out there that we just don't know what's going to happen with that. And it's huge because it sounded like a lot of money, having close to $90 million. But when you figure out how many people are getting that money and how much money each person is getting, each tenant is getting, you realize that there's not enough money to cover all the applicants. So whereas initially we thought there was going to be plenty of money here, we're now hearing that the money is going to probably run out, assuming that the city can figure out how to do it and get through the systems and get the money out to the people. So if you still have rental assistance that you need to apply for, do it as quickly as possible.
Okay.
Okay.
Moving on to the evictions part of this. So one of the rules that the city had put out, the laws they put out when this initially came out, was that we could not file a complaint until 45 days after what we had originally believed was us reaching out to the tenant in order to apply for phase 4 rental application, rental assistance, excuse me, because we need their permission. So those 45 days started to toll, we believed, after we reached out. We were told we had to reach out to the tenants 3 times within 10 days, which is what we've been doing. Now we're being told we go to file for an eviction. We haven't done one yet. Colleagues of ours did it. All of us attorneys got on the phone so that we could talk to each other about this, and they're getting rejected. Actually, they're not even getting rejected. When you file a complaint, it's getting flagged. And if it's not a breach case, if it's a non-payment of rent case, and it's getting sent up to the president judge, who is reviewing these, and he's withdrawing them, keeping the court costs and withdrawing the cases if he feels like you didn't meet the threshold of reasonably trying to reach the tenant. Additionally, he is now stating that you have to at least file for the rental application, those first 2 pages, because that's the only information you're going to have on the tenant, because you can't get in touch with the tenant, and the 45 days starts tolling from them. So colleagues of ours went and filed and had their cases withdrawn because one of those 2 criteria weren't met. So the rules have changed once again, and nowhere is this written, nowhere. This is just the judge and the courts taking it upon themselves to review every single complaint that's being filed down at court.
Yeah, and this is the judge arbitrarily deciding this after the fact. So they issue the rules and regulations. They tell you, here's what you should be doing. Everyone's doing that. And then on the back end, they say, oh, you know what? We're not going to accept this. We don't think it's sufficient. But they didn't tell you on the front end what is sufficient. So now they're writing the rules and regulations to try to tell us what is sufficient so that everyone can follow it. It's just a nightmare. The one word I've been using is to describe all this is just disaster. This is just all a disaster, but hopefully we're coming to an end of it. Got word from Judge Wolf, who's the administrative judge, yesterday, that they are not planning on extending the moratorium any further after the end of this month for alias writs and to be able to lock out tenants. So as of yesterday, at the end of the day, that's what we're saying. Check back again at the end of tomorrow and see what happens.
The good news about that is all the people that you had judgments on prior to the phase 4 rental applications, we should be able to start moving forward on those. I mean, I think the highest we had, Tim came back and told us the highest we had a judgment on was $32,000. I don't know if anybody can top that as of yet, but we have a judgment for $32,000 on a residential tenants. So we should be able to start moving forward on some of those lockouts. And then once those 45 days toll from when the applications go in, we should be able to start filing the evictions on those, subject to the review. We have to still keep making those attempts to reach the tenant, and what the judge is considering sufficient attempts is anybody's guess as of right now. But the hope is that the reason that's being so scrutinized is because there's still money and there's still a moratorium. The hope is once the moratorium is lifted and the money starts dwindling, that scrutiny won't be quite so tight, we believe.
Yeah, so there's a lot going on. I know we've been jumping around a lot this morning. I want to kind of step back and try and go through the whole process for you quickly so that we can make sure that you're doing everything that you need to be doing from a legal standpoint and to get the money for you for the rental assistance.
Yeah, real quick before you do that, Paul, Frank just had a quick question on the 45
Yes.
days. He's saying you may not receive an eviction for 90 days from the last month in which the landlord receives rental assistance in the program. Yes, and Paul may explain this a little bit as he goes through the process, but correct. If the rental application is approved and you receive funding, you cannot file for an eviction for 90 days post the last date that you receive the payment. What I'm talking about with the 45 days is in the case where the tenant is not cooperating, so that we can't get through the rental application, the rental assistance application. So that 45 days starts, we believe, from the third attempt of trying to reach out to these tenants so that we can file for phase 4 rental application, for rental assistance. However, the courts are now saying this 45 days start tolling from the point you put that you start a rental application. You can't complete a rental application without the tenant's permission and cooperation. So if you don't have their permission and cooperation, at some point, the clock has to start tolling so that we can file the eviction. So it just doesn't go on indefinitely. That's the 45 days I'm talking about. Okay. And Paul might explain that a little bit as he goes through the whole process here.
Yeah, those 45 days and the 90 days are two totally separate issues.
Right.
So going back last March of 2020, the CARES Act was passed. And under the CARES Act, if you had a covered property, you had to send a notice to your tenants, kind of like a notice to quit. Even though it's waived in the lease agreement in Pennsylvania, it was required under the CARES Act if you had a covered property. We thought that that law was done by the end of December. Most people believe that to be the case. Then the government came out with new guidance saying, oh no, just kidding, you still have to send that notice out. Even though the law really doesn't apply anymore, we think that that section of the law which requires the notice still does apply. Most attorneys throughout the country, including myself and Janelle, believe that the law does not apply and you should not have to send a notice. And if you read the language in the law, you shouldn't have to send a notice. But the guidance that the government is issuing says you do have to send a notice. It doesn't hurt to send a notice at this point in time. You're not getting into court, as Janelle said before, 45 days anyway. So we're recommending to everyone as the very first step, if you have a covered property, to make sure that you're sending out that notice. So that's the first thing that needs to be done. Okay. If anyone's confused about whether you have a covered property and all that, I think we have the 5 YouTubes on that.
Yeah.
over the last year. And
Go back to like one of the original ones.
Yeah, or just contact us and we'll go through that again with you. I don't have time today, this morning, to go through that whole CARES Act. All right. But just know and keep in your mind that if you do have a covered property, you should be sending that 30 days notice. The next thing that happened in Philadelphia was you had to send out a hardship repayment notice and a notification of rights to the tenants before you could proceed with an eviction. The hardship repayment notice gave the tenants a period of time within which to pay the back money that was owed. Additionally, they wrote into the law that you had to notify the tenant of what their rights were. The hardship repayment plan has pretty much gone away because it only covered the period of rent that was owed, back rent that was owed through the end of December. And now if you have back rent that's owed, you're probably getting the rental assistance. So it most likely doesn't apply at this point in time. But the city has said that notification of rights piece of that still does apply. So it's kind of like the CARES Act notice. If you have a covered property, you still have to send a notice, even though we don't think the law applies. In the city of Philadelphia, you still have to give that notification of rights. So the notification of rights was tied into the other part of it, even though the other part of it really doesn't exist, the notification of rights still does. So you still have to send out that notification of rights. The next thing that the city did was they said you have to apply for diversion. I hate that word. It's really mediation, but they want to call it diversion. I'm not sure why. It's mediation, but you have to apply for that before you can file for an eviction. So you want to be sending out that notification of rights and you want to apply for diversionary program.
However,
exactly. The city said that now before you can file for an eviction, you have to apply for rental assistance. As part of the rental assistance law, they said when you apply for rental assistance, you are automatically enrolled in the diversionary program. Great, we no longer have to apply for diversion because you're applying for the rental assistance. It's all covered as one. That's what the law says. However, in actuality, what happened is when they passed the law, they hadn't figured out how to get you enrolled automatically in the diversion program. So the first thing we were doing is we still had to apply for diversion. Then the next thing that happened was they figured out how to get you enrolled automatically in diversion. So that was great. And then moving forward, I guess it was last month, they decided that, oh, you know what? We have too many cases and we can't figure out how to do this. So now you're not automatically enrolled in the diversionary program, but sometimes you are, depending on the type of case it is. So that's a whole nother nightmare that we're working through. If you're not going to be automatically enrolled, then you probably have to apply separately for diversion, something we're doing for you. So we're figuring that out to make sure that that's all taken care of as part of the process. The key to all this, I'm trying to tell everybody, is rental assistance. You want to push for that rental assistance. Tenant owes you money, figure out some way, somehow to get them that rental assistance. It's only as a last resort where they can't get the rental assistance that we should be going forward with the eviction cases. There are, however, as a caveat, there are certain instances where you have to bring the eviction case to force the tenant to cooperate and go through the rental assistance. It's unfortunate. The city is helping us to try to notify the tenants to get them enrolled in the rental assistance. The key is that rental assistance is huge. There is a lot of money there. We want to get all your tenants the rental assistance. Anyone that owes you money, we want to make sure, or try to make sure, that they get the rental assistance. That's job number one, is getting them that rental assistance.
We understand this city kind of did this backwards because there's no fire, there's no teeth at this point. We've literally had tenants say to us, I had one of my staff people tell me, the tenant said, well, why should I cooperate with you? You can't lock me out. What's the difference? We were astonished. We couldn't believe the tenant said it to us. But that's some of the thinking of the tenants right now. So it's pretty funny because there's no threat. They're right.
So that's kind of the steps that we have to follow to get through this process. On the back end of this, once you have a tenant that has vacated the property, let's say they vacated the property, but are still able to qualify for rental assistance. So now the question becomes, can you get the rental assistance for somebody that has vacated your property? For months, I was telling everybody that under the law, it specifically says you can't get rental assistance once somebody is out of your property. The purpose of rental assistance was to keep people in your property. The whole concept of the rental assistance was to stop the spread of COVID-19. And the argument was that when people are thrown out of their house, they're now put in congregate living settings, they're out on the street, they're going to spread COVID-19. And the government gave this rental assistance to stop the spread of COVID-19. So if the person was already out of the property, giving them the rental assistance wasn't going to help them. And that's the way the law was written. So we told everybody, you can't get the money on the back end. That's what we were told. The city then came out and said, City of Philadelphia came out and said, oh no, you actually can get rental assistance even though you're out of the property. It's like, what? How's that possible? They said, yes, absolutely. You can get the rental assistance. So now we're telling our clients, sorry, we made a mistake. You can now get rental assistance even though the people are out of your property. The problem is that the computer system is not set up for you to be able to push the right buttons to be able to get the rental assistance if the person's out of the property, because you have to upload a lease agreement. And once you upload the lease agreement, that lease agreement has expired and you no longer qualify under the federal guidelines. We've worked it through with the city to figure out how they can adjust their computer system so that we are going to be able to do that. So as of last week, we're now being told that the system's going to be straightened out any day now so that we're going to be able to go ahead and get that assistance. Keep in mind, however, that sorry, I got Siri talking to me. Keep in,
I thought you like got muted or something.
It's a bad morning. Sorry. So keep in mind that Janelle and I believe that the law does not allow for that, but the city is saying you can get it. So are you going to be able to get it? Your guess is as good as mine. We'll just have to wait to see what happens as far as that goes. We're going to be applying for it for all those cases. We're going to try and get it for you guys, but don't hold your breath. Who knows what's going to happen with regard to that?
Okay, we have a couple questions. Paul, can I read through some of
Sure.
these? Okay,
Sure.
Corinne's asking on the application, it has a box. Oh, too many questions are coming on. I can't see anymore. Box for diversion, so they should check no, correct. If you haven't automatically been enrolled for diversion, yes. If you haven't already applied for it, check no. The idea being then they're supposed to be enrolling you in diversion when it's applicable. Okay. Do you need a current?
If you say yes, you have to have that P number,
Right.
and they're going to ask you for that P number, and if you don't put that in there, you won't be able to get to the next screen.
Okay. There's a ton of questions. Sorry, it keeps jumping down. Do you need a current rental license for tenants to apply for rental assistance?
You don't need it for the tenant to apply. You're going to need it for you to apply.
For your
So
part?
yes, so the bottom line, the short answer to your question is yes, you're going to need that rental license to be able to get the rental assistance.
Okay. Can you done on this topic yet? Victoria, we'll do that another day. We're trying to just do the topics that we have to cover today, or else this is going to be way too long. If you have a question, just call our office, and our office can help you on that. Okay. What should a landlord do proactively if they receive phase 4 rental assistance, which includes future rent, but the tenant stopped communicating with the landlord and there's no expectation the tenant will resume paying rent in the ordinary course once it becomes due again in September 1? Okay, so if you have rent, let's say through the end of August, you'll have to wait the 90 days. So what I would do in September, if they don't pay September's rent, make sure you're sending out your CARES Act notice if it's applicable, your hardship repayment notice, in September once they're delinquent, because you're not going to be able to file until November, December. So you want to get all those steps complete ahead of time, maybe file for diversion. And then that way, once you can file after those 90 days, you can go ahead and move forward. Okay. You cannot, I'm sorry.
Yeah, go ahead.
I was just saying you can't preemptively file. The 90 days or the 90 days.
So the way the rental assistance works is you get the back money and then you can get up to 3 months going forward each month. And then at the end of the 3 months, you have to recertify for the next 3 months. If the tenant has used their income tax return as their documentation for the COVID financial hardship and the loss of income, then they won't have to upload any additional information to recertify after the 3 months, because obviously their tax return hasn't changed. If the tenant's used unemployment, if they've used pay stubs or any other documentation to prove the hardship and the loss of income, then at the end of 3 months, you're going to need the tenant's cooperation, because the tenant's going to have to upload that additional information. And then if you can't get that information from the tenant, then do everything Janelle just said, so that we can proceed with the eviction. And then as we're proceeding, we try to contact the tenant, and so does the court system, so that hopefully somebody will get a hold of the tenant to be able to get the tenant to go ahead and upload the additional information, so you'll be able to get the ongoing rent.
Okay. Next question. What if your residents don't qualify for rental assistance because they have a fixed income that was not affected? Yeah, that actually happened with us, but you still have to apply. You'll apply, they'll get denied, and then you can go ahead and file. Those cases where they're being denied for a reason like that, we are hearing will not have a problem with them being withdrawn up at court. Unfortunately, in the situation where we had, I believe the tenant wound up paying or something along those lines, so we didn't have to file. However, you should be okay to file. And you do have to go through the process, but it'll get denied. And it gets denied, I think, relatively quickly. Amanda can speak to that a little bit more, but yeah.
If it's denied, it's been taking the city forever to approve or even view these applications. So we have pages and pages of pending applications. So we've had a few denied. However, the clients decided for whatever reason they're not filing, the tenant's paid. As soon as we get our next denial, we're going to run it as a test to see if it goes through with the city, to make sure. And we're hoping that since they didn't qualify, that we should be able to file, because that's what we've been told.
So we'll see. Stay tuned. Jamie, I'm going to take all that as a rhetorical question. Is there an end to this craziness? We hope so. We think the end is going to be next month. So
The end is near.
we hope. I don't say anything in absolutes anymore, Paul. Okay, if a resident applies for rental assistance and leaves, are we still able to collect rental assistance? Well, that's what Paul was just talking about. We don't, the law is written such that you can't. City of Philadelphia is saying you can. So we hope so. Do you suggest getting residents on the rental assistance with large balance or just start to file? You can't start to file. You have to apply for rental assistance first. You cannot file until 45 days after you apply for rental assistance. This is what just came down last week to us from the city. So of when that 45 day starts tolling. So you can't, like, you have to apply. So yes, that's the answer.
One of the issues with the large balances and what we're finding is the tenants who are applying on their own, the ones that we're not doing their applications, but we have to go in, it actually ends up being a little bit more work for us, the ones that are applying on their own. One, if they need help and they are not figuring out their application, we need their username and password. We can't see their application or do anything at all. And what we're finding is the tenants, for whatever reason, do not know their balance that's due, or they're not asking for enough money. So we need to get the ledger from our clients and compare it so that we can be sure that we're getting you the exact amount of money that's due. So that's causing a little bit of a delay because the tenants call us back, they don't have their password's wrong, and then we have to get the ledger and compare it and push it through, and then hopefully it gets approved. So if you get an email for us asking for a ledger, please send it as soon as possible. That way we can go on with the tenant, walk them through and fix the amounts due for on their application.
And that should answer some people's questions that we're asking that, when they didn't line up. We are taking care of that. And we do communicate with the city. Amanda has contacts down there and she's communicating with the city when the tenant puts the wrong balance in so that we can get that fixed. Okay. What if the resident hasn't paid, is non-responsive, and will not qualify? You still have to apply. They'll get denied because of their income. If they're non-responsive, that's when the 45 days comes in. You put the first 2 pages in on the rental app, you wait 45 days, then we can file. You have to try and keep contacting them. We have to show that you kept trying to contact them, and then we can file, right? Can we begin charging late fees? July? Well,
It depends, but for the most part, not through the end of September.
September.
That's if they have a COVID financial hardship.
Just so you know, they're
So-
considering everybody. That threshold's very low. So the answer is basically September.
And those people should qualify for rental assistance. You should be able to get rental assistance for those people.
Due to the lead testing fiasco, a lot of our rental licenses have late dates on them. The city zip code list was not working. It's causing penalties in rental assistance dates. Any suggestions? I would contact the city. If it's not one we're doing for you, and we can contact the city for you if we're handling it for you. But problems with that, you need to contact the city. There is a way to put a ticket in for it's like a help Zoom, right, Paul?
Yes, it's a online meeting appointment. So you don't have to actually go down to the city. You can do it online. It takes a couple of weeks though to get into the queue and to actually get the meeting. I do meet with the head of L&I and the head of the health department weekly. And I submit emails to them, which they do respond to. So I can't deal with individual issues that you're having. They asked me because I started sending them to them and it was just too many and they started freaking out. It's like, Paul, you can't be doing this. So what they said was if you have like overall issues that affect a lot of people, I can get those questions to them or those items to them so that they can change their system to fix those things. So if you have any specific problems that are not any general problems, not specific problems, any general problems that you're experiencing across the board, send those to me and I can email the city and get them taken care of.
Okay. Same thing for you, Evie. Just what Paul said with regard to matching documents. You're not the only one who's told us that. Okay. So they don't have a financial hardship. Can we charge a late fee? You could try. I don't know how successful we're going to be in court, but you can try. Can we send out notices to quit letters? Yes, but at this point, most notices to quit are waived in your lease. I believe yours are, Haiti. You're gonna wanna send the other notices that we were referring to out. They need to be sent out anyway, but you can, and if you wanna send a late letter or notice quick, that's fine too.
But they
That's
can't
the- Mhm.
threaten eviction though, right? It can only say, hi, like your balance is this, but they can't threaten to evict them. Was my understanding.
Right, which is why we said just send the hardship repayment notice out that we're talking about with your notification of rights, with your balance. Okay. Does the 45 days start from the date the application was successfully submitted or from the date of a denial? This was the issue we ran into last week. It's not from the date of denial or an approval. It's from the date that you get. So what happens is, and Amanda could speak to this if I'm wrong, you apply, there's 2 pages, the first 2 pages on an application, once you fill them out, it's basically your info and the tenant's like contact info and date of birth, you get a number. I forget what's the number called, Amanda?
It's called a P4A number.
You get a P4A number. And when you get that number, the 45 days start from the date you get that number. We just got clarification on that about a week or 2 ago. That's the date that, I mean, when you get that number, the date starts running at that point. And I think we're finally done the questions.
So right now in our office, we are working day in and day out to apply every single tenant that you have sent to us to create their application. Before we were tracking our calls and our emails to them. We also have been sending certified letters in the mail to the tenants that are completely unresponsive any way, shape, or form that we are able to get in touch with these tenants. We have tried. However, now we are going on and just applying all of them. So if you get an email from us asking for any information that we need for your end, just let us know. That way we can put you in our system and get it up there even quicker.
Sheila, that's a good question. She's asking if a tenant was going to be locked out last March, hasn't paid a thing since, is not cooperating, will the lockout proceed if the alias writ was in place before the shutdown, or do we need to keep trying to get permission to apply for rental assistance? We don't know the answer to that. As of right now, the way the law is written, we believe, and Paul was stating, we should be able to start filing the alias writs starting in July. However, we're just waiting for the courts to say you're not allowed to file a writ or an alias writ, so you try and apply for rental assistance.
You're going to most likely have to apply for rental assistance. I hate to say it.
Just reading between the lines, I can't imagine they're not going to do that. But as of June 22nd, they haven't put that requirement out there yet. So, but again, it doesn't expire for another 8 days. So my guess is they're going to put an order out saying that the moratorium expires, but that you can't file a writ or an alias writ for however many days after you apply for rental assistance. It's just my guess. We'll see if Paul and I are right.
So we've all been on these Zoom calls and people have like cats walking across the screen. Now we have like strange men walking across the screen.
My computer was about to die. It wasn't plugged in. I was at like 8%.
Just saying.
Shut it off.
So Jason came and brought me my charger. Okay, I'm going to stop on questions for now because a lot of them are just asking about denials and stuff. And like Paul said, if you're having issues with the denials, you're going to, like I said, if we're doing them for you, let us know. Well, we'll know, and we deal with the city. If not, you're just going to have to put a help ticket in and wait and talk to the city about the reasons for those denials, okay? What if we have the writ, we only need lockout date? Again, we don't know, guys. We're just guessing. As of right now, once the moratorium is lifted, in theory, we should be able to just proceed and go forward with alias writs and lockouts. But I find it hard to believe they're not going to put some type of rental assistance requirement on those writs and aliases. I'd be shocked. But then again, I was shocked when Wolf didn't extend the moratorium last time. So we've been wrong before. So I don't know.
Just to add, I did reach out to like my contacts higher up, like the head of the landlord tenant office, and they said that they have no idea what's going on. So they don't even know.
Yeah, we're just guessing. So as soon as we know, either an email blast will go out, or if it's complicated, we'll have another Zoom. Okay. Marley keeps putting up, which is great, this our YouTube channel, so that anybody who needs to rewatch this or wants to show, colleagues that couldn't be on the call, it'll be on there later today. Okay.
Yeah.
Okay. Paul, do you want to, well, before we do that, Marley, are you good with everything that you wanted to talk about on phase 4?
I think so. Just if anybody we are obviously inundated with phone calls all day from tenants. We do have a very organized way of handling everything. We just ask if we email you for information, if you can get it back to us, that way we can get everything in as soon as possible for you. Amanda Lux has been a rock star. She is best friends with everyone down in the city. She has been working, I think, like 55 to 60-hour weeks with the rest of our Philly team. And essentially our whole office is really working on phase 4 at this point, because as you heard, this has been change after change after change. So we're trying to stay ahead of it all. Obviously now we have to backtrack a little bit to get everyone in there, but we are doing so day in and day out. And please know, like Janelle mentioned in the beginning, I'm doing this myself as well. So I would say for every third application, the website fails. It takes forever to get back up. It takes about 10 to 15 minutes to put in a completed application. And there is nothing more frustrating than when you get to the last page of the application and you press submit and the website runs and runs and runs, and then everything gets deleted. And it's not just us experiencing this, it's our colleagues that we're in touch with every day. They are also experiencing this. So our office is working as quickly and efficiently as possible to do this. And every day there is some type of roadblock, essentially with the city. And as Paul said, the kinks in the website. So
Hang in there is basically what she's saying. Hang in there. We got you. But it's, yeah.
About phase 4, I wake up in the middle of the night every night just thinking about P4 numbers. All we talk about. And it's been crazy, but thankfully we are in touch with the city. And like I said, they're calling us, asking us questions, and we're just like, really, guys? Paul said disaster. We're hoping to shift the word disaster to, Paul, give me a word, success, less delinquency, anything to get out of the disaster hole. But we're here and we're doing it. If you have any questions at all, please email Amanda Lux. Amanda Radcliffe is no longer with our firm. People are still emailing her. Please email Amanda Lux.
Amanda, put your email in the chat so everyone has it, okay?
Yeah. I'll put Amanda, me, and April. And
Okay.
my whole office is working on Philly rental assistance. We would be your 3 main contacts.
Yeah, put them in there and that's good. Okay. Paul, do you want to talk about some of the new laws that are being passed this week in Philly?
Sure. So there is the Fair Practices Ordinance that was introduced by Councilwoman Kendra Brooks. This has gone through a lot of iterations. We met with the councilwoman on numerous occasions. Actually was trying to get the bill killed. Don't think that landlords need another regulation. I think you have enough to try and follow in the city of Philadelphia. I tried to explain that to her, tried to go through it all with her, explain how landlords are leaving the city, especially your smaller landlords. It just doesn't make sense to be a landlord in the city of Philadelphia to have to comply with all these laws, but they just don't care. So the reality is there were some changes that were made to it. It was amended last week. It will be coming up for a final vote on Thursday and most likely will get passed. I don't want to go through it in too much depth in case it doesn't, and in case things change. We're still trying to change some things with regard to the bill, but I do want to make you aware of it. You should watch for it because it's something that you are, as a landlord, going to have to comply with. And basically what it says is that you have to have uniform rental screening criteria. And that criteria needs to be either on your website, posted on the premises, or some other way given to the tenant. I did get confirmation that if it's included with the application, that will be acceptable. But mind you, when I say I got confirmation, that's the legislator saying it's acceptable. It doesn't mean the courts are going to say it's acceptable. So what you're really going to want to do is make sure that whatever your rental criteria is, that it's posted on your website. There will be organizations that are going to look at your website to see whether or not that criteria is on the website. So you're going to want to make sure that you do have this. One of the things I love about the law is that in the law it says that you have to have an individualized assessment based on uniform screening criteria. Now think about that. An individual assessment based on uniform criteria. How is that possible? You have uniform criteria. Either you qualify or you don't qualify based on this uniform criteria, but we're going to do an individual assessment. Well, if you're doing an individual assessment, how is that uniform? You got to love this fair housing stuff. It's just incredible. But that's what the law specifically says. Individualized assessment based on uniform screening criteria. So you're going to have this uniform criteria that you're going to put on the website, but you're not going to apply it uniformly. You're going to apply it individually. Okay.
One of the
The
best
key
things you can do, I always say, is make sure that you have a appeal process for people. One of the things HUD likes to see is that you have a way of, if they get denied, that they can appeal. Hey, this isn't me. Hey, this happened 30 years ago. Hey, here's some documentation to show why you should still accept me. Whatever the case may be, they like that appeal process. It's a good way to kind of satisfy that individuality portion of it.
Yeah, absolutely. You're going to have to give the tenant the reason for the denial and provide them with all the third-party documentation that you use to deny them, provided it doesn't violate the Fair Credit Reporting Act. What you cannot do is have an absolute blanket policy where you either exclude somebody based on an eviction record or where you exclude somebody based solely on a credit score. So you can have your criteria, which says that you have to have a certain credit score, but you individually have to look at that person to see whether or not they should qualify, even though they don't have that credit score. I know that makes no sense, but that's what the law says. Okay. So what you're really better off doing is not putting a specific number. You want to say things like an approximate score. It's kind of like if you apply to get into Harvard and they tell you that you generally need a score in your SATs over 1,500. But if you're over 1,200, you can still apply. You never know. You might get in. Yeah, sure. If you're an athlete that's a pitcher that pitches left-handed and can throw 84 miles an hour, yeah, you might get into Harvard as a pitcher.
You're so
But you're not getting in based on your academics.
For those of you not in the loop, I am in the middle of going through the college process with my son, who's a junior and a left-handed pitcher. So Paul thinks he's funny.
Yeah, but the bottom line of it, so you don't have a hard and fast, here's the credit score number that you need. So you can have a recommended number that you're looking for, but you will certainly still evaluate the person just like Harvard will evaluate you if you have a score that's lower than that amount.
Okay, real quick before you move on that same vein, when does this go into effect? We don't know. Once it gets passed, they'll give us a date of when it's effective.
It's I think it's 90 days
After it becomes law, but we don't know 100% when that'll
after
be.
it passes. It will most likely get passed by council. This ordinance will take effect 90 days after it becomes law. So Thursday will most likely get passed by city council. Then the mayor has to sign it. The mayor will be signing the bill, assuming it gets passed. We don't know when he signs it. So he usually signs it within a week. So you can figure it'll be 97 days or so. It will become a law.
What about criminal? That's one of the factors. As Paul started about credit, criminal, income. It's all one of your. It's included in your factors.
Yes.
Mike,
The big thing that,
sorry, go ahead.
yeah, the big reason behind this law is they want to have a sealing bill get passed, and the city can't pass the sealing SEALING, where they seal the records. So the city can't legally pass a sealing bill. They don't have the constitutional authority to do that. It has to be done through the state. So this is a backdoor attempt at a sealing bill. And in this bill, it says specifically you can't have a blanket policy of just excluding somebody because they've been evicted. So you have to actually look at why they were evicted and give the tenant an opportunity to say, you shouldn't consider this because I was in the right, the landlord's a slumlord, the landlord's done this wrong, what have you. You have to give them that opportunity. So if you have a blanket policy that says if the person has an eviction record, we're excluding them, you're violating this law. If you have a blanket policy that says we're excluding somebody based on their credit, you're violating this law. Okay.
Okay, someone's asking, what if they don't have a website? You want to have it posted in any place where you're advertising to the tenants, whether that's, you can post it in your property, you can put it on your Facebook page, wherever you might have your tenants reach out to you.
Yeah, and if none of the above applies, like you don't have any other way to post that somewhere, then make sure when the application is filled out, it's part of the application, that you're giving that to the tenant when they're filling out that application and giving you that payment for the screening fee, that they know what the criteria is at that point in time.
What
Okay.
about felonies? Can you exclude a tenant? That's a topic for a whole other day, Russ. This isn't just about criminal. You contact my office and we can have a conversation about that.
Yeah, the criminal gets more into the HUD guidelines for
Correct.
criminal than the city law. So yes, that is a whole separate.
We've done whole
Seminar that we've
different
done.
seminars on that. Okay, but just
Okay.
give us a call. We'll explain.
Now, there are certain things that you absolutely cannot use to exclude renting to the tenant. Does that make sense? There's certain things that you can't use as a
As-
means to
only
justify
means for
denying the
denial.
tenant.
Yeah.
Yeah, I'll get it right. Okay, so they are, if the non-payment is due to some COVID-related hardship, or it was during the COVID emergency period, which ran from March through the end of December, then you can't use that to exclude the tenant. So if they had a prior history of non-payment and that history was during the period of COVID-19 emergency period from March through the end of December, you cannot use that as a means to exclude them. If there was an eviction on the record, but no judgment, so a landlord has filed for an eviction, but there's no judgment against the tenant, you cannot use those eviction filings. Similar to the innocent until proven guilty. So if someone's charged with a crime, you can't use the fact that they've been charged with a crime against them. If they've been convicted, you can use it. Same way here, just the fact that they've been filed against, you cannot use that against them. This is one of the one of the things that really annoys me that they put into this law that I was trying to exclude, and that if the judgment was vacated or satisfied, you can't take that into consideration either. So there's a judgment against the tenant for a certain amount of money. You got possession, the person paid that money, judgment's been satisfied. You can't use that against them and turn them down because of that. And the final thing is if there was a judgment by agreement that was entered into with the tenant and the tenant's following that judgment by agreement, you can't use that against them either. So they went to court, they owed the money, the former landlord entered into an agreement where they were going to pay that out over time. Even though they may have been evicted, there was that judgment by agreement. You can't use that judgment by agreement, which is just totally wrong, but that's in the law. The tenant has the right to dispute whatever they want to argue as far as the denial goes. And then you would have to review it. And that gets into what Janelle was saying, is you should have some type of review process in place for reviewing these denials to see whether or not they should be approved. And the final thing is that the law will be reviewed in 18 months. I'm not sure what that means other than they're going to look at it in 18 months. They're actually forced to look at it in 18 months and decide whether or not they want to keep that law. So it's somewhat helpful, not very. My guess is they'll look and say, yeah, we're going to keep it. So I don't think it's going to help us a lot, but they threw that
Or
in
they're
there.
going to add some stuff to make it even worse.
Yeah, there you go. Yeah, exactly. So that gets you up to date as far as Philadelphia goes. Just for those of you, 2 seconds, for those of you that have properties in New Jersey, today's a big day in New Jersey as far as being able to do the evictions. The way the law was written there is you couldn't do an actual lockout until 60 days after the end of the health emergency. The health emergency is ending finally, so that 60 days should have ran. However, the governor said, oh, sorry, except for with regard to evictions, we're going to extend it through the end of December. They're now playing with that date depending on how much money the tenant makes. So if they have a certain percentage of AMI, that may not get extended to the end of December. It may only be till the end of August or the middle of November, depending on how much they make. So they're playing around with those numbers that we should hopefully have a decision on some point today. So watch for that for those of you that have properties in New Jersey.
And there's been some other laws in New Jersey. We're going to have a New Jersey Zoom. We're just waiting for some things to kind of become finalized. So those of you with property in Jersey, just keep an eye out for the New Jersey Zoom. The courts are also trying to figure out how to deal with the backlog. And there's been a lot of different things with regard to that. Different meetings that actually our office, Matt Bradley from our office, have been invited to and has been going. So when we have some more concrete answers, we'll have another one of these for Jersey. And I know we've been getting asked a lot of questions with regard to PA. We are waiting for the federal moratorium to be lifted at the end of this month to see if it gets extended. Once that happens, we will either have an email blast go out or a Zoom to let you know what's going on in Pennsylvania, because we don't know as of right now. We have a lot of judges that, you know, kind of went rogue and did their own thing and their own interpretation of that CDC moratorium. Some, you know, didn't even let us file. Some pushed our filings out till July. They're starting to call us to reschedule them. Marley just let me know that yesterday. So that's good news. But until we know in about a week or so whether it's going to get extended or whether and what's going to happen, we are just in a wait and see hold pattern. So we'll be letting you know about that as well. I know.
And I did want to leave you all with a little word of advice. And that is, if at first you don't succeed, do not try skydiving. Sorry. Hey, listen, it's Father's Day. So if,
no, it was Father's Day
dad,
2 days ago. You're done.
I know, but I'm saying, and I got a week. Dad jokes are okay for at least a week.
I got a week. Does that mean after this week you're done with the dad jokes?
No.
I didn't think so. All right, guys. Like I said, this is recorded. We'll have it up on our YouTube later. The Phase 4 help desk number. I know a lot of you had questions and on who to reach out to. Amanda Lux put that in the chat. So quick, write that down. Also, there's emails for our office in there. If you need help, we can help, especially for those of you, you know, who we've already been working with. Just if you have questions that I couldn't get to today, please reach out to my girls. And that's it. Have a great rainy Tuesday.
Thanks, everybody. Have a great day.
Bye.